Thank you for staying with us. Now, Ghana's President John Mahama has removed Chief Justice Gertrude Torkornoo after a government inquiry found she misused public funds and overstepped her powers. Now, she had been suspended since April while the panel examined thousands of pages of evidence and heard from many witnesses. The commission concluded that there was enough to recommend her dismissal. Mr. Torkornoo says that the claims are false and politically driven, while many lawyers and opposition figures worry that this decision could weaken the independence of Ghana's courts. They fear that it makes it easier for the executive to pressure judges. Now, the law is also vague about what counts as misbehavior, which critics say leaves room for political interpretation, because she's been removed from the Supreme Court but can still challenge the decision in court. So for now, the move has raised serious questions about checks and balances and whether the judiciary can stay free from political influence. For now, I'm joined by Gilbert Arhinful-Aidoo, political science lecturer, University of Education in Winneba. Thank you so much, Gilbert, for your time and for speaking to us on this.
Thank you for having me.
It's a pleasure.
It's a pleasure. Thank you.
Now, Gilbert, the presidency says that the Article 146 committee found grounds of stated misbehavior and that the president acted on its recommendation. Do the committee's findings meet constitutional threshold, for removing a chief justice? Tell us.
Okay. Thank you once again for having me. I want to greet your viewers across the world. First of all, I want to indicate that I am not a lawyer, and so most of the things I'm going to speak to will bother more on the political, institutional, and administrative stuff.
Yeah, but the Constitution doesn't have anything. Yeah, the Constitution doesn't have anything to do. It's not just for the lawyers. Even as a political science lecturer,
yes,
I still know about
my commentary will not go much into the legal issues, but to comment on the substantive issues and whether or not there's reasonable grounds to remove the CJ from office. Now, again, to also indicate that the full report has not been made public. And so as I speak, I do not have the full content of it. And if I should say or speak about the substantive findings of the committee, that would be more speculative. And so I would limit myself or restrain myself to the letter issued by the spokesperson of the president or the minister for communication, and also the available pieces that are found in the media space already we've been talking about. But first of all, let's look at the Constitution, Article 146, and the main ground for removal of the CJ. And it's indicated that where there is a stated misbehavior, incompetence from performance of one's duties as the CJ due to either illness or perhaps insanity of mind, the CJ could be removed. And so by the letter of Ghana's constitution, the president has followed through the due process in subjecting the petitions through the appropriate means of getting the CJ removed, following the complaints made by some 3 citizens of the country. Now, we are told the issues border on administrative, or if I should say bad governance or poor judgment in terms of the CJ's administrative services or performance. And this particularly has to do with her travelings with her family and the payment received as per GM to both the husband and the child. Now, I tried to check whether this is wrong or right. And when once there's no legal or administrative basis for payment to these people, it has become a convention in most institutions in the country that once somebody is up there, they get certain privileges, and sometimes their family also tend to benefit from this. But what makes the CJ's case even serious is that there was a similar matter earlier on that got to her office to rule on, and this was bordering on when there was a proposal that spouses of president and vice president should be paid allowances and salary as though they were ministers. Now, when it got to her desk to look into the matter and make a ruling on it, her ruling was asked that under no circumstance should the spouses of president and vice president be paid any allowances or salary as though they are ministers. And so for the same person to have done this administratively, then it is, in my view, unpardonable in the first place to rule on the one hand that somebody else could not benefit from their husband's position or wife's position, and for you to hide behind the scene and talk about convention in giving something that you are barring others from receiving to your own. That is unpardonable. And so I found that to be a serious issue administratively against the CJ. But that said, I think perhaps if that had been handled well, engaged the offices and powers that be, they could have handled it in a different way instead of leading to the removal of the CJ. But on the second issue, the integrity of the institution, which is a judicial body, and mind you, she is the overall head of the judicial system in the country. And so there are certain decisions when you take, it brings the integrity of the court to disrepute. Now, one of such instances borders on certain posturing and commentaries prior to the 2024 elections.
Okay, well, just before you go ahead, Gilbert, let's also talk about, the process, the process which was held in camera, because the committee chair had actually said that in camera proceedings, they're not the same as in secret. So what do you think? Is this distinction persuasive to the public, or does the secrecy feel more suspicious?
I don't know if I got your question right. Are you trying to ask whether having a meeting or discussing the issues in camera is the same as
doing
keeping
it
the
off
issues
camera? Yes.
Thank you. Now, whether or not that is right, we still have to look at the Constitution. The Constitution indicates strictly that such happenings should be done in camera. If I am not mistaken, Article 146, I think, was the 7 or 8. That 8. All proceedings under this article shall be held in camera, and the person in question is entitled to defense. Now, having the discussions in camera, perhaps due to the sensitivity of the office, the issues involved, and mind you, the thing is that some of the issues may be discussed at the end of the day, they may not lead to removal of the persons in question, and they would have to come back to their duties. And so if they expose certain things to the public, that may embarrass the person, may create some insecurities and what have you for the individual in question, then coming back to continue their duties, they may have a lot of challenges to face. Again, if we want to move away from the in-camera thing, then we have to agree to amend the Section 8 of the Article 146 to ensure that going forward, these issues are open to the public so that nothing is hidden, because we are told that sometimes when some of these things are held in camera, at the end of the day, some of the key issues may not be published, may not be made part of the final findings or reports of the committee, and so the public will be kept in the dark, and so there's a need for certain public hearing. But until the Constitution is changed or amended, that provision is amended, and there is little that can be done with regards to the in-camera hearing.
All right. Now, still speaking on the Constitution, are there mechanisms that exist under Ghana's 1992 Constitution to prevent the executive from weaponizing petitions under Article 146? And are those mechanisms even sufficient enough?
Thank you. Following the letter of the letters of the Constitution, one would say or would want to believe that there are clear steps, processes, and mechanisms for reprimanding the various arms or heads of the various arms of states, not only the judiciary and Article 71 office holders. But you and I know that in Africa, everything is possible. So sometimes there are some machinations, manipulations here and there. There are some political and some cards played that may go against individuals that may be perceived as enemies of a particular regime. So yes, there are clear stated mechanisms and what have you, but some of them are quite ambiguous, because if you say stated misbehavior, as we speak, that I think it came up in Parliament when the majority leader in current administration even raised it, that we need to go a step further to define what should constitute the stated misbehavior of these office holders, so that nobody can hide behind stated misbehavior on the part of heads of these constitutional creatures to use political coloration, what have you, to get them out of offices. And so, yes, the Constitution spells out some steps and processes, indicates at what point you can be removed, but we need to go a step further to clearly define the threshold that may constitute the misbehavior, misdemeanor, what have you, under which you can be removed.
Okay. Now, in your view, do you think that this removal could lead to criminal investigations or even prosecutions for the alleged financial issues, or is this strictly a constitutional administrative matter? Because, you know, according to the petition, it alleges a specific sum of 261,890 Ghana cedis, and also $30,000, that's US dollars, tied to travel and per diems.
Thank you for this question. Now, I have always put up a certain attitude that it doesn't matter who is involved with what or in what. If there are enough basis for proper investigation, for prosecution into certain misbehavior, corruption, corrupt deals, and what have you, the state should take the necessary steps to deal with the individuals in question. But all of this should be done within the confines of the law, in order not to be seen as witch hunting or using the opportunity to settle personal scores. But I think if the findings of the committee is so glaring that there are other improprieties that deserve further probing, then there's a need to go into that, because no one should be treated above the law, and everybody must be subjected to the same standards. So if the former CJ is found to be guilty of certain financial improprieties, which has been found through the committee's work and through the petition sent, then the appropriate institutions like the IOCO, the Office of the Special Prosecutor, what have you, should get involved, get to the bottom of it, and deal with the matter as it is. When it becomes necessary to prosecute further, the person in question with regards to the financial crimes and any other crime found, why not? You should be able to do that. To set a certain example for any office or every office with that in the country, to be careful when they are using the resources of the country, the scarce resources of the country.
All right, Gilbert, speaking of setting precedents, now we know that several lawsuits challenging the process failed. So how do Ghana's courts evaluate procedural fairness, in removal inquiries? And also, why do you think that these suits failed?
Your question is a bit difficult one for me to answer, but I'll try to attempt it, pointing to some issues raised by the public. Now, what makes this particular issue a little dicey has been the political angle it took. Now, before the election even happened, there were concerns raised about the posturing of the CJ and how that was undermining the integrity of the judiciary. Whether that is true or not, we are yet to put the evidence adduced further to understand what actually went there. But somebody had taken a certain posture. People have raised eyebrows about the person's effort to do the bidding of a certain government in the past. And so there were warning signs given here and there that when we come and we find anything, we will get back to you. And unfortunately, the person in question also didn't handle herself so well on certain matters. Now, for example, between the majority in Parliament and Speaker, when there was a ruling about people who had cross-carpeted and whether or not they should maintain their position. Technically, the procedure, the suit filed and all of that was wrong, and it shouldn't have been the way forward. The CJ simply should have referred the matter to the High Court because it didn't have original jurisdiction over the matter, so that when it is referred to her, she and her court would then get the opportunity to set matters straight. But of course, she played into the gallery, which also led to the allegation that she was doing a bidding of certain political big guys. By saying that there was a certain constitutional crisis in Parliament, there was a need to save the situation, and the open commentaries that she made, making herself so powerful, forgetting that the politician can always use any means possible to get to you. Now, when even issues were raised about the panel that she constituted to look into the matter, one person who had interest in the matter because of his political connection to the majority who had filed the suit, she still rubbished it, cited examples that were irrelevant to the case in question, and none of the people she cited to buttress her case were even sitting on the case in question. And the person in question did not also recuse himself when issues were raised about one Justice Gahu for his political connection to the individual who brought the matter to court. Now, when you do all of that, you set yourself up. So I've said several times, especially to my class, that sometimes you do certain things, you set yourself up. And so when the politician gets to you, then you find it difficult to clear yourself. Now, she has raised a number of challenges that she had going through the process. Denial of sometimes her family to sit with her, getting her phones through and all of that to the sittings, what have you. But these are erroneous matters to the main issues we are discussing here. And even though I still believe that there were political push in getting the CJ out, she herself had contributed to the situation. And so one would want to believe that the president had followed the due process. You may not be happy with it, but There was a certain rot in the system which you contributed to it.
All right. Well, just before we're actually winding down. We only have 1 more minute for you. But in that 1 minute, can you tell us how this decision will affect Ghana's international reputation, especially for investors, development partners concerned about the rule of law? What can the presidency also say or do to manage that risk?
Okay, thank you so much for this question. One, I want to say 2 things. The first is that either way, allegations of improprieties have been raised. Do we investigate or let it lie? That was still going to affect the integrity of the country's judicial system and rule of law. Because it means that we were going to sweep under the carpet certain important concerns, and that also add to the challenges and doubts people have about the judicial system and its integrity.
Okay, Gilbert. Well, sadly, I'm being told that we need to wrap up right now, but thank you so much for your time and for speaking on this.
Thank you for having me.
Thank you, Gilbert Arhinful-Aidoo, political science lecturer, University of Education, Winneba.